So students, in this lecture number 10 on the Code of Civil Procedure, we will discuss the definition of public officer which has been given in section 2 subsection 17. The definition of public officer which has been given under section 2 subsection 17 is an inclusive definition. According to the definition of public officer means a person falling under any of the following descriptions. It is very important. If any person fall under any of the descriptions which is given under section 2 subsection 17, then that person shall be regarded as public officer. It means to say if any person does not fall within the following description, then he shall not be regarded as public officer within the meaning of section 2 subsection 17. So what are the various persons who can be classified to be the public officer? These are: number one, every judge. Every judge is a public officer within the meaning of section 2 subsection 17. Number B, every member of an all India service. It means every person who is the member of an all India service, he shall also be regarded as public officer. Number C, every commissioned or gazetted officer in the military, naval or air forces of the Union while serving under the government. So, during the service tenure, every commissioned or gazetted officer of the military, naval, or air forces of the Union shall be regarded as public officers. And after their retirement, what will be their status? They shall not be regarded as public officer after their retirement. D point deals with the persons who are the officers of the Court of Justice. First of all. Secondly, it tells about the persons who are authorized by the Court of Justice to do those works which are to be done by the officers of the court who can be regarded as public officers within the meaning of section 2 subsection 17. What clause number D states? Let study it. Every officer of a court of justice whose duty it is as such officer. So these duties are as such their officer. Number one, to investigate or report on any matter of law or fact. If any officer whose duty is to investigate on any matter, that matter may be of law or that matter may be of fact. If any officer of the court is doing the duty to investigate or report on any matter of law or fact, he shall be regarded as public officer. Number two, or to make, authenticate or keep any document. If any officer of the court prepare any document, authenticate any document, or keep any document in his custody, then he shall also be regarded as public officer. Or to take charge or dispose of any property. If any officer of the court take charge any property or dispose any property as such officer of the court, then that officer can also be regarded as public officer. Or if any officer execute any judicial process, then that officer shall also be regarded as public officer. Or to administer any oath. If any officer of the court administer the oath of persons, he shall also be regarded as public officer. Or to interpret or preserve order in the court, he shall also be regarded as public officer. And it is very important to make focus here that every person is specially authorized by a court of justice. That person may not be the officer of the court, but even then, if he is authorized by the court of a justice to perform any of such duties which the officers of the court are doing, then he shall also be regarded as public officer within the meaning of section 2 subsection 17. What E point states, if any person holds any office by virtue of which he is empowered to place or keep any person in confinement, then he shall also be regarded as public officer within the meaning of section 2 subsection 17. Normally, what are those persons who has the power to place or keep any person in confinement? They are the custom officers, they are the excise officers, they are the police officials. They have the power to place or keep any person in confinement. Even the bailiff of the court has the power to place or keep any person in confinement under order 21 rule number 37 as well as under order 21 rule number 41 of CPC. Number F, every officer of the government. So these are the officers of the government whose duty it is as such officer to prevent offences. First duty of the police officer is to prevent the offences. Hence, the officials are regarded as public officers to give information of offences, to bring offender to the justice, or to protect the public health, safety, or convenience. It include the persons who are doing their work in the medical stream. They are also regarded as public officers within the meaning of Section 2, subsection 17. Under the G point, every officer whose duty it is as such officer to take, receive, keep, or expend any property on behalf of the government. First of all. Number two, or to make any survey, assessment, or contract on behalf of the government, or to execute any revenue process, or to investigate or to report on any matter affecting the pecuniary interest of the government, or to make, authenticate, or keep any document relating to the pecuniary interest of the government. They are also called to be the public officer within the meaning of section 2 subsection 17. And lastly, under point number H, every officer in the service or pay of the government, or remunerated by fees or commission for the performance of any public duty, are also regarded as public officers within the meaning of section 2 subsection 17. So this was the bare language of public officers within the meaning of section 2 subsection 17. From the definition, some comments are to be discussed, and these are: if any person who is not an officer of the court but has been especially authorized by a court to perform any of the duties given to the officers of the court under clause number D of section 2 subsection 17, shall also be a public officer within the meaning of section 2 subsection 17. Number 2, the commissioned or gazetted officers of the military, naval, or air forces shall be considered to be public officers till the time they are serving under the government. After that time, such officer shall cease to be the public officers. A person may be a public servant without being a public officer. There are certain categories of persons who are the public servant, but they cannot be regarded as public officers because they are not doing the work which has been described under section 2 subsection 17. For example, the PN of a bank, the PN of a government department, they are the public servants, but they cannot be regarded as public officers because they are not described in section 2 subsection 17. Some of the officers who have been held to be the public officer by the Supreme Court and by the High Courts are: number 1, a judge of a High Court is a public officer; minister of a state; receiver appointed by the Civil Court; official assignee; an officer in the Indian Army; administrator general; an inspector of police; official trustee, official liquidator, a village headman, a custodian of evacuee property, an advocate engaged by the government on any day fees. These are some examples who can be regarded as public officers. And what are those persons who have been held not to be the public officers? These are: municipal councillor cannot be the public officer. A retired government servant is not a public officer. Chairman of a municipality is not a public officer. Officer of an insurance company or of a corporation cannot be regarded as public officer. Sarpanch of a panchayat, liquidator appointed by the registrar of cooperative societies cannot be regarded as public officers within the meaning of section 2 subsection 17.